Assalamualaikum and good day to everyone. So our group will present about personal bars to a claim for specific performance as enumerated under Specific Relief Act 1950. So this is our group members. Now we will move to introduction. What is specific performance? Specific performance is a court order directing the defendant to perform any promises made or responsibilities imposed on him by the parties' acts, whether expressed or implied. In English law, specific performance is a type of equitable remedy. It is evident that the court is staffed and guided by certain regulations when implementing this remedy in its judicial procedure to make sure that any party in the legal processes is appropriately awarded this equitable remedy. In Malaysia, the other party to a contract has the right to legal recourse if the other party fails to uphold their half of the deal. Those conditions require the defaulting party to perform the contract's obligations. Then the Specific Relief Act 1950 therefore establishes the rules for specific performance remedy in Malaysia. Specific performance is generally granted as a remedy in cases where monetary damages will not be adequate to compensate the aggrieved party. For example, in the case of a contract for the sale of land, specific performance will be granted if the seller failed to transfer the land to the buyer, as monetary damages will not be an adequate remedy in that case. When a party seeks for specific performance, must show that they have fulfilled their contractual obligations while the other party has not. When deciding whether to award a special performance as a remedy, the court will consider several considerations, including the contract's nature and the case's circumstances. It is crucial to bear in mind that the court in Malaysia has discretion when granting for specific performance as a remedy. Therefore, the ability of the party to get a specific performance is not always assured. It is also dominant to speak with the lawyer in order to comprehend the legal process and the likelihood of receiving a certain performance remedy in a given situation.
Provisions regarding specific performance. First and foremost, it is vital to determine the circumstances where specific performance is enforceable. Based on Section 11 of Specific Relief Act 1950, the specific performance of any contract may be enforced when 1. The act agreed to be done in the performance wholly or partly of a trust. Second, there is no standard for determining the actual harm brought on failure to carry out the negotiated act. Third, the agreed upon act is such that monetary compensation for non-performance will not provide adequate relief. Fourth, it is probable that pecuniary compensation cannot be got for the non-performance of the act agreed to be done. Moreover, the court is discretionary to grant specific performance as a remedy in personam. The remedy mentioned has been given the discretion of the court based on the relevant section, which is Section 21. It is stated that discretion as to decreeing specific performance. The jurisdiction to decree specific performance is discretionary, and the court is not bound to grant any such relief merely because it is lawful to do so. Still, the discretion of the court is not arbitrary but sound and reasonable, guided by judicial principles and capable of correction by a court of appeal. The following are circumstances in which the court may properly exercise a discretion not to decree specific performance. A. Where the circumstances under which the contract is made are such as to give the plaintiff an unfair advantage over the defendant. 2. There may be no fraud or misrepresentation on the plaintiff's part. B. Where the performance of a contract will involve some hardship on the defendant which he did not foresee. Meanwhile, there is no hardship on the plaintiff on its non-performance. Next, move to the part where the specific performance of a contract cannot be enforced based on Section 23 of Specific Relief Act 1950, which indicates about the personal bars to the relief. According to the Act, specific performance of a contract cannot be enforced in favor of a person who could not recover compensation for its breach, b. who has become incapable of performing or violates any essential terms of the contract that he still needs to perform, c. who has already chosen his remedy and obtained satisfaction for the alleged breach of contract, d. who previously to the contract had noticed that a settlement of the subject matter thereof, though not founded on any valuable consideration, has been met and was then enforced. Thus, this stated type of parties are unable to ask the court to grant specific performance related to the factors of unenforceable derived from this section.
Assalamualaikum and hi, my name is Amnan Hakim bin Suhaimi. So today I will tell you guys about the case that can be related to this provision. The first case is Yap Seong Yi against Eureka Property Management Sdn Bhd and another appeal 2018. In this case, Eureka agreed to buy a property from Madam Yap. They agreed to pay 1.8 million plus 10% deposit in the payment. After a few months, Eureka did not make the full payment to Madam Yap as she did not deliver the document as requested by Eureka. Then, Eureka filed suit 13 for breach of the first SPA. While suit 13 was on pending, Madam Yap agreed to sell the property to Pra-Ram. Madam Yap refused to present the balance purchase price of RM400,000 in a solicitor's letter dated 13 July 2011, when Eureka tried to sue her for specific performance. She then revised her defense and counterclaimed to eliminate the specific performance prior and accepted Eureka's contract repudiation. Eureka filed a new suit against Pra-Ram, seeking damages for fraud in executing the second SPA for the same property with Madam Yap. The Court of Appeal held that the learned judge misapplied the law and the principle governing the grant of a remedy for specific performance. Eureka had a choice on the date of the claim breach between claiming damages for breach of contract or seeking the remedy in the form of specific performance. Furthermore, Eureka did not make all reasonable steps to maintain the status quo of its claim. According to Section 23 of the Specific Relief Act 1950, a company which had become incapable of completing its end of the deal could not apply to the court for a specific performance remedy. The second case is Sekemas Sdn Bhd against Liang Seng Ko Sdn Bhd 1989. The parties in this case established an agreement in which the respondent agreed to sell and the appellant agreed to buy a plot of property in Kuala Lumpur for RM15.1 million. The appellant was obliged to transfer unoccupied possession after paying the full purchase price. The respondent has levelled all of the structures on the property in preparation for future development. Following that, despite being given more time, the respondent was unable to pay the final amount. The respondent transferred the property to the appellant despite not having received full payment. The appellant was unable to pay the remaining balance of the purchase agreement and sought that any funds paid in line with the agreement be repaid, with the exception of liquidated damages. In their response, the respondent requested that the appellant complete the purchase and emphasized that the agreement clearly called for the remedy of specific performance if the purchasers fail to pay any portion of the sale price. The respondent also pointed out that the agreement clearly called for specific performance as a remedy. The respondent demanded specific performance from the appellant, and the learned judge in the High Court issued an order in response. The court dismissed the appeal for a variety of grounds. A remedial option is specific performance. Although Section 20 Clause 1 Clause A of the Specific Relief Act states that a contract will not be specifically enforced if its non-performance can be adequately relieved by monetary compensation. Section 11 Clause 2 of the Act makes it clear that monetary compensation cannot be an adequate remedy in contracts for the sale of immovable property. The court may refuse to grant specific performance relief to the plaintiff if doing so would inflict an unforeseen hardship on the defendant. This is according to Section 21 Clause 2 Clause B of the Specific Relief Act. Overall, the court concurred with the learned trial judge when he indicated that the appellant had inflicted difficulty upon himself by deciding to embark on the expensive interview without appropriate funds. The court admitted that the appellant had inflicted difficulty upon himself by embarking on the expensive interview without appropriate funds.
So for the last part, I will give a conclusion that was discussed by all my group mates. Here I need to highlight that there are 3 sections in the Specific Relief Act that will affect the specific performance itself. So for the first section is about section 11 of the SRA, which mention the circumstances where the specific performance is enforceable. Next is section 21, highlighted that the discretion as to decreeing the specific performance. And the last section will be section 23, where the specific performance of a contract cannot be enforced. So in my view, I will highlight that specific performance is a good as it gives positive position to the parties. However, there is a complaint about specific performance. Firstly, it can be difficult to enforce and it's not always acceptable or workable. Let's say in the case of Venkat Chalam RM Chetia against NKR Arunasalam Chetia. In this case, there is possibility that the specific performance will be granted. However, due to the discretion of the court, the specific performance is not allowed even if the high value property depreciate worstly. All in all, specific performance can be utilized to enforce contract when monetary damages are insufficient.
That is all from us. Thank you.